So what's up, guys? It's your girl, Legal Beast, attorney Kiana Franick. And so, I made my post earlier out running my errands today. I just finished my second errand, which was a Target run. And now I'm on my way to my third errand and third location, which is the pharmacy. But so while I'm doing this, I've been catching up on the Crumbley closing, the Crumbley Trial closing. And I gotta say, honestly, I think the prosecution could have lost this in closing from reviewing the entire closing. So let's get into it. So, if you don't know, my name is Attorney Kiana Franick, and I am a criminal defense attorney in the state of Michigan. I have a practice in Southfield, which is in Oakland County, Michigan, where the Crumbley Trial has been proceeding. I've been practicing approximately 15 years. I practiced throughout Michigan and Ohio. I have my own firm, and I do criminal, I do family, and I do real estate in various forms. So this is just my 2 cents, my opinion as a criminal defense attorney and a parent throughout the pendency of this case. Just as a disclaimer, I've never worked on this case. I have never worked at the firm on this case. I have not reviewed any discovery. I have not reviewed I've not worked in the prosecutor's office. I have not done any of these things, and I have no close ties or relationship to this matter other than the fact that I live very close to where this occurred, and I practice in the county that it's in, and it's a precedent setting. It has the potential to be a precedent setting case. So now you know who I am. If you didn't know, now you know. So let's go. I am completely underwhelmed by the closing of the prosecution. I think there was so much more potential and room to go after certain facts that were brought out. The lack of certain facts, I think that showing the pictures of the witnesses like throughout the testimony and this PowerPoint presentation, I think, okay, we get it, but they saw them in person. It's not having the same impact. What I really think needed to be done was literally a roadmap of the negligence, spelling it out, whether it's on the PowerPoint presentation or a dry erase board, like literally, figuratively writing it out in each branch and prong of the elements and which fact goes with it. I think that in the closing, they focused a little bit too much on the defendant's son, the shooter, than her willful, neglectful acts. I think they needed to literally write out each individual, and this is what I would have done. Write out what each individual act was that was neglectful, that was willfully neglectful, which gave indicia of flight, what gave indicia of guilt. Where did the duty come from? What is the duty? Where are you getting this duty from? Because I think just initially looking at it, someone can easily say, well, how do I have a duty to someone else's child? Well, technically you don't, but you have a duty to control your own, which is why parents can be brought into juvenile court for truancy, for delinquency, for neglect, etc. And so I think spelling those things out was really, really needed. And she said them, but they weren't as impactful because I believe she focused on the young man too much. She focused on the shooter so much that I don't think she focused enough on Miss Crumbley herself. Another thing is I really think would have helped the prosecution with their case is if they had actually charged Jennifer Crumbley with child neglect or abuse. Because then proving that would have proven the neglectful aspect that you are arguing for this breach of duty, for this willful neglect. So if she was charged, if they were charged with child abuse, or if they were charged with child neglect, along with the involuntary manslaughter charges, I think that the underlying basis for even the involuntary manslaughter could have been satisfied if they were also able to prove willful neglect or child abuse as to the shooter. And tactically speaking, because you're saying that she was essentially neglectful to her child, and she was neglectful in her duties as a parent, and she was willfully neglectful in her duties as a parent, then therefore she is directly responsible for the outcome of this case. She was directly responsible for the outcome of purchasing a firearm for a minor, teaching that minor how to shoot, not keeping that particular keeping the firearm locked up in a case where he did not have access to it, not taking into consideration him raising his own issues of needing a doctor and mental health, and just kind of putting it off. Those are all things that I think would have easily satisfied a charge of child abuse and neglect, and in doing so would have satisfied, I think, the underlying basis and duty for the willful for the involuntary manslaughter. This is my opinion. I am interested now to see how the defense is going to bridge their defense and the negative aspects that came out about Miss Crumbley. But I really think that this closing was so... I think so much was left on the table with this closing, and they did not save time for rebuttal. If I'm not mistaken, they were not going to save time for rebuttal, that, you know, this really can go anyway right now, and I can't wait to see how the defense handles this. So I'll check back in with you guys once I get to closing. Closing out the defense. So see you later.